Welcome to today's program titled COVID-19 Lender and Borrower Fundamentals. At this time, I'd like to turn it over to our presenters. Go ahead.
Hello, everyone. Welcome to this webinar, which will focus on issues faced by commercial lenders and borrowers in light of the COVID-19 crisis. My name is Mitchell Kaplan, and I'm a real estate partner in the New York office of Seyfarth Shaw. I hope everyone listening to this webinar and their loved ones are staying safe in this tumultuous time. Today is March 31st, and we thought this brief presentation would be timely in light of the multitude of loan defaults that will likely start to occur beginning in April due to so many businesses shutting down, apartment dwellers losing their jobs. It's resulting in severe shortages in cash flow for commercial and multifamily real estate borrowers. I will be moderating the panel for this presentation, and joining me today, all of us, of course, remotely since we are sheltering at home, are our panelists. They are as follows. Aaron Goldman, who is a real estate partner in New York at Seyfarth and Shaw. James Soker is a bankruptcy and creditors' rights partner in our Chicago office. Both Aaron and James will be speaking from the viewpoint of a secured lender in this presentation. We also have Miles Borden, a real estate partner in our New York office, and Toby Pinsky, a real estate partner in our Chicago office. Both Miles and Toby will be speaking from the viewpoint of the borrower in this presentation. So just want to set the stage as to what we'll be generally talking about. So we'll assume that we have a mortgage loan that has either gone into default already, payment or covenant default, or in fact may go into default in the near term. As I said, it's March 31st, and April payments will be coming due possibly in the very next day. So some of these loans or the scenarios may be, again, existing default or possibly an anticipated default. Although many of the concepts and topics that we will be discussing will be applicable for most property types, for purposes of the following discussion, we'll assume we're primarily dealing with previously performing cash flowing multi-tenanted properties such as office buildings, shopping centers, or multifamily properties, which have now been negatively impacted by COVID-19 due to the closure of non-essential businesses, moratoriums in some places on non-essential construction projects, such as tenant build-outs and even ground-up construction, and sheltered home directives. There will be some, federal and state stimulus dollars possible, but for purposes of this conversation, we'll assume that these borrowers may or may not be eligible, but at this time, we're not aware of funds that are eligible. If they are eligible for funds, obviously that may impact discussions between the borrower and the lender because there may be additional funds to pay debt service and operating expenses. So, which brings us to the next slide. Let's talk about initial contact and preliminary analysis. Toby, would you like to start us off, given the stage that I've set, and from the borrower's perspective, how you would initially attack this and deal with this issue with respect to your communications with your client and of course, with the lender or lender servicer?
Thanks, Mitch. So we're finding in discussions with our borrower clients that unlike the prior downturn, borrowers are wanting to be more proactive in getting in touch with their lenders. First, they're reaching out to us to generally discuss their concerns. And as you indicated, it varies a bit from loan to loan and from property type to property type. Does the borrower have a concern right now that there is a current monetary default or the potential for a monetary default if they are not going to be receiving rent come April 1st? Or is the borrower more concerned about a current or future breach of a covenant under their loan. Is the property so underwater that the borrower might be thinking about an exit strategy from the asset? Are they really just trying to buy time for the property to become cash flowing again? Or in the reverse, are they trying to take some sort of ultimate protection to prevent a claim under their guarantee? And once we have initial conversations with our client, we then tend to turn to our loan documents to analyze what the loan documents say, both for what can trigger a default under those loan documents and also what can trigger some sort of recourse against a guarantor. So the borrower has to be aware before they approach the lender what kind of recourse carve-outs there are and what kind of conversations they might have that trigger those. And they also want to make sure they look to their other guarantees which may be in place, whether they have a completion guarantee or a carry guarantee, and at the end of the day, who is backstopping those guarantees. Following those conversations, we're recommending that the borrower then develops a strategy for approaching the lender. And in some cases, that might just be a phone call to the lender to say, this is the status of my project, this is the status of my tenant. And in other cases, it might be a more formal written notice to put the lender on notice and say, we've had some sort of problem with the project and we want to make you aware, and how can we go about either ultimately modifying the loan or just having an initial discussion about it.
Thanks, Toby. So we've heard from Toby on the borrower side as how this will be initially approached. From the lender side, obviously, they have to take some preliminary steps and analysis as well. So, Aaron, would you like to start us off and tell us how a lender would basically approach this? They may be doing some similar things as Toby mentioned on the borrower side. So I'll hand it over to you as far as some of the preliminary analysis that will go into the approach on the lender side.
Thank you, Mitchell, and hi, everybody. So from the lender standpoint, after the lender hears from Toby or her client, the lender has to kind of digest the information, and one of the first steps the lender has to take at that point is to make a determination if they've received a communication, they've received a phone call, they've received a letter that indicates that there's been a default. And if the lender determines there has been a default, the first thing the lender will then do after that is, or should be doing after that, is sending a reservation of rights notice or letter to the borrower and the guarantors on the transaction. Now, in today's environment, the content of that notice is very fluid, and there's a few different approaches a lender could take, knowing that sending a letter of that sort could have significant consequences, not only for this loan, but for other loans as well. So there's kind of a sliding scale, I like to say, in terms of reservation of right notices. On one end of the spectrum, a lender could simply reserve their rights. They could reference the default. And then as you kind of go down the sliding scale, the lender may wish to be a little bit harsher with the borrower and the guarantor, calling out the specific default and demanding that it be addressed within a specific period of time. And then kind of at the far end of the spectrum, the lender could actually send out a default notice, and depending on the type of default and whether it's an event default under the loan documents, the lender could actually accelerate the loan in that initial communication. Again, with the COVID-19 situation going on, the lender really has to think long and hard as to essentially what type of position and what type of tone it wants to take with its sponsor when getting that letter out the door, assuming it's heard of some sort of default in the communications, which came in from the borrower and the sponsor. Now, no matter which way the lender goes in terms of the letter that's being sent, and in fact, no matter whether the lender heard that there was a default or not, after getting this communication, the lender is in all likelihood going to want to gather some more information, and this is what we're hearing from our clients. Let's hear more about what the status is of the property, what the status is of the tenants at the property, what are your new projections? Give us some more information, and then we could start thinking about next steps. And then under normal circumstances, certainly these aren't normal circumstances, a lender, if they had a loan that was either in default or about to go in default, one of the initial steps in this context would be to review the loan documents. Kind of on the flip side of what Toby mentioned, the lender would review the loan documents to see what their remedies are, to make sure everything's in order, to really start formulating an enforcement strategy. Obviously, with so many loans having issues now, that may not be possible at this particular point in the back and forth stages. So those are the initial considerations for a lender after hearing from its borrower and guarantor.
Great. Thanks, Aaron. So just hearing, just for a moment, hearing what I've heard from Toby and from Aaron, the flip side as far as information about the property. I mean, Aaron just mentioned getting detailed financial information and what it looks like. One thing that I have heard from some lender clients, only being into this crisis for the last couple of weeks or so, is some borrowers have approached lenders right off the bat and said, I want a 6-month forbearance or tolling of going after us, and without any real backup to come up with any kind of time frame. And I think the lenders, their general response is that's not going to obviously be acceptable. We are going to need to know lots of details. And so I think from the borrower's standpoint, to be able to move forward in constructive discussions and negotiations with their lenders, that they should be prepared to provide the detail that Aaron had actually just mentioned. So just wanted to add that to the conversation. So
Mitch,
go ahead, Miles.
You're absolutely right, and part of what we've been counseling on the borrower side is anticipating all those things that Aaron was laying out, the need for the lender to have current information, as well as the borrower understanding the cash flow and its cash position with respect to the property, because up to a few weeks ago, we have been in the best of times. Properties, for the most part, have been cash flowing, paying their debt service. The assumption here is that most of these tenants have paid certainly their March rent, which is used to service the April payment, so that a lot of the borrowers I'm working with are perfectly fine continuing, whether it's through automatic payments or actually making payments of their debt service for April, but using this time to signal to a lender that perhaps we need to have a discussion, and to do it in a cooperative manner. And that's sort of the response that I'm seeing from a lot of lenders. It's a cooperative situation at this point, where I think it's to everybody's benefit to try to manage through, given the specific facts about the loan and the property.
Great, thanks, Miles. And I think on the last point, I think all the lenders that I've spoken with, they are trying to be as cooperative to make this work for everyone, recognizing that they are fairly overwhelmed at this point, but they're working as hard as they can to get to a place where everyone will ultimately be happy, or just not terribly unhappy. So moving on to the next slide, as far as what will be the next steps here, I think at this point everyone's done their initial analysis. And in order for both borrower and lender to talk freely, it'd be beneficial to both parties to enter into some type of pre-negotiation agreement. So, James, would you like to kind of run us through some of the general concepts that would go into a pre-negotiation agreement and what it's there for in terms of beneficial aspects for both the borrower and the lender?
Sure, Mitch, I'd be happy to. Thank you. So as Mitch indicated, pre-negotiation agreements can really benefit both the borrower and the lender in this situation, and they benefit the parties by allowing for open discussions by the borrower of defaults and potential defaults, as well as potential solutions in the exchange of information between the borrower and the lender. And the way this is done is that the parties in writing agree that the communications made in the context of the pre-negotiation agreement are settlement communications and are therefore inadmissible as evidence in any subsequent litigation, whether pursuant to Federal Rule of Evidence 408 or any state law corollaries. This way, the parties are comfortable that they're able to share information and really try to work together in a cooperative fashion without risk of being prejudiced. So that's the general idea with respect to it, which takes us to some of the basic terms of a pre-negotiation agreement. So one of the most important and basic principles is the reservation of rights by the parties. They're entering into the pre-negotiation agreement and want to have an open exchange of information, and neither side wants anything to happen that happens during the discussions to prejudice their side. So from a lender perspective, you don't want to have any of your rights or remedies prejudiced because you've engaged in discussions with the borrower regarding a potential forbearance or loan modification going forward. Obviously, the goal is to reach a binding agreement that's going to solve the problem, whether it's a forbearance or a loan modification. So one term that's often in these agreements is that the parties agree that any subsequent agreements arising after the pre-negotiation agreement must be in writing and must be signed by both sides to be enforceable. That way there's no dispute over whether or not an agreement was reached with respect to the parties and whether or not it's binding. Certainly a common term in pre-negotiation agreements is the additional due diligence information that was just discussed by Miles and Aaron to enable the lender to understand the borrower's situation. And because of that, an additional provision in pre-negotiation agreements is often the confidentiality of the information provided by the borrower to the lender. And oftentimes, the parties may request that any information be provided be treated as confidential and that the confidentiality provision will survive the termination of the pre-negotiation agreement. Therefore, the information and documents exchanged remains confidential. It's following the discussion. So beyond that, then, lenders oftentimes will request releases from the borrower of claims and actions in engaging, in entering into pre-negotiation agreements. And the lender's leverage, obviously, to get these depends on the borrower's situation. If it was an otherwise healthy loan going into this, and this is strictly a COVID-related issue, it may be more difficult to get. But if this was a troubled loan going in and the COVID-19 outbreak was the final straw, the lender may be in a better position to demand releases of any claims or causes of action that the borrower may have had against the lender prior to entering into the pre-negotiation agreement. Another common provision is treatment of costs with respect to the negotiations and going forward. To the extent that the parties don't agree to put anything in, it's more likely than not that the loan documents are going to control, and more often than not that the borrower is technically going to be obligated to pay costs. Finally, another provision that the parties may want to negotiate in putting in is with respect to termination of the pre-negotiation agreement. On the lender side, you're essentially going to want it to be at will and be able to decide at any point in time that negotiations have broke down and that the lender is able to take enforcement activities. Of course, the borrowers may seek to negotiate a certain set period of time on that. And then finally, another provision that the parties might wish to address is the lender's receipt of payments during this time period, whether they be full or partial payments, and preservation of the lender's rights and how the funds will be treated. So that's kind of the overview of the general terms of a pre-negotiation agreement.
Thanks, James.
On the borrower side,
go ahead,
the
Miles.
borrower side on this, I'd particularly want to be careful that the reservation of, well, not so much rights, but that anything that's discussed under the pre-negotiation or prior to the pre-negotiation can't be used by the lender. As best as we all counsel our borrower clients, and quite frankly, our lender clients, there may be phone conversations where, with the best intentions, either side is either sort of maybe admitting to too much that they shouldn't be, or saying, don't worry, things will be okay, we'll work with you. So I think, it behooves both parties that any conversations prior to the pre-negotiation agreements are folded in.
Thanks, Miles. Just going back to a couple of quick points that James mentioned. So, James, you mentioned the issue of confidentiality from the standpoint of the borrower's side, providing all kinds of financial information with regard to the borrower, the sponsor, and the property. Of course, there are certain parties on the lender side that would have to be able to obtain that information, lawyers and consultants, presumably if it's a CMBS deal, the various servicers, controlling holders, and possibly the rating agencies. But I would also think that from a confidentiality standpoint, the lender may have maybe not as great concerns, but they would probably want to maintain confidentiality as well in this overall restructure as between just this borrower, this sponsor, and this lender, and not get out in the marketplace whatever deal may ultimately be cut as far as a forbearance or a loan modification. The other thing that I just want to ask at this point, and probably directed toward Toby and Miles. So we've been talking about a first mortgage loan, but there may be a more robust capital stack with a mezzanine lender involved here. Just curious, from the borrower's side, would the discussions generally be with the senior mortgage lender at first? Would you go down dual paths if you had a mezz lender before you just cut a deal with one lender? Just curious from the borrower's side how you would approach that where you have more than one lender in your capital stack.
I would go down dual paths, and at some point during that process, I think it would behoove everybody to let both lenders know that is what is occurring, because ultimately, as when the senior mortgage loan and the mezz loan, many times close simultaneously, or even if they're closed at different points, all three parties, so to speak, have to work together. So that's my take on there.
Yep, and that makes sense. And the intercreditor agreement between the senior lender and the mezz lender will generally provide each has to approve. Now, in a workout situation, there's much greater flexibility for each lender to cut their deal, but there will still be some limitations as far as certain modifications that each party will have to approve. Okay, so assuming one other thing about the agreement itself, the pre-negotiation agreement, and hearing both sides from the borrower and the lender side, there are things that if we were in normal times and we're just dealing a one-off problem loan or potential problem loan, the terms of the pre-negotiation letter may be negotiated over a period of days or even longer than that. But given the dire consequences and the number of loans that will likely go in default, I think it probably behooves both parties to have a kind of right down the middle, even-handed pre-negotiation letter to get things started. So assuming that the parties do agree on the terms of a pre-negotiation agreement, at that point, lender and borrower would likely move into more substantive discussions regarding the loan and the property. and how possibly to move forward in an acceptable manner to both parties. And that would lead us to next slide, which is the terms of forbearance agreement and or a loan modification. So why don't I start off on the lender side as far as sort of the general concepts, purposes of the forbearance agreement. Aaron, you want to lead us off there?
Sure. Thank you again, Mitchell. So as you indicated, the next step would be to put together a forbearance agreement. And from a very high level, the concept behind the forbearance agreement is that there's a default out there and the lender is agreeing to forbear from exercising its rights and remedies, and it's going to give the sponsor some time to take some steps to address the default or the defaults, as the case may be. Now, most forbearance agreements are set up where there is a time frame where the lender is going to forbear from exercising its rights and remedies, and sometimes there is simply just a date. And then other times there are triggers set up which will bring the forbearance period to an early close. So the typical forbearance agreement will reference, well, if there's other defaults under the loan besides the one that we've been focused on, that may mean the end of a forbearance period. There's also a possibility, and part of the discussions at this stage would be, well, we've got some defaults that are spelled out in the loan agreement. We just said that if one of those occurs, that's a trigger to the end of the forbearance period. But possibly under in today's environment, a lender may want those to be a little bit more robust. And they may seek to have other triggers besides just the specified events of default. And additionally, a lender could put in there that certain outside events would trigger the end of a forbearance period. Some government action that maybe we're not foreseeing today, but that occurs down the road. Something that is kind of outside the four corners of the loan documents, something like that could be the end of a forbearance, could mean the end of a forbearance period. And once the forbearance period ends, the way the forbearance agreements are generally set up is then the lender is again entitled to proceed with exercising its rights and remedies.
Great, thanks, Aaron. So I want to, I guess, go over to the borrower side. I mean, there are some things that Aaron mentioned that a lender would like to see in the forbearance agreement to strengthen the lender's position. I suspect, Miles and Toby, you may have a different view on that as to what should be in there and what may trigger or would not trigger earlier acceleration. So, Miles or Toby, you want to jump in here?
Yeah, the first thing that I'd like to jump into is, and the reason we're reaching out to a lot of our clients, is to avoid having this discussion in the concept of a forbearance agreement and more in line of a loan modification. So we're trying to avoid the default given the situation and have a frank conversation with the lender and get some relief, which and realistically offer up some suggestions as to what that relief would look like, whether it's a month or two of debt service deferral. If it's deferred, what happens with that? Is it put at the back end of the loan and paid with the balloon? Is it perhaps the deferred amount amortized over a series of months during the term? Discussion about things, is there interest on interest? Looking at other covenants under the documents where we may need relief because of COVID-related delays, having discussions about maybe using certain reserves, perhaps, to pay debt service or make sure that it's used to pay taxes and insurance and things like that. So our sort of focus is to avoid the default and enter into a modification, again, which I see as a less onerous and tough document from a borrower's perspective.
And just to add to that, it may be that the lease has certain restrictions with respect to leasing and that there are adequate reserves for maybe TI and LCs, and that the borrower just needs better access to those in order to keep the property cash flowing. And that the borrower just wants to ensure that they don't wind up in some sort of cash trap and they can continue to pay operating expenses as they've always incurred them, and that they're able to continue to manage the property as they've always managed the property. And so as Miles said, to continue that open line of communication and just make sure that the borrower is exerting suggestions where it has ways that they can benefit the particular property, possibly prior to a default situation.
Thanks, Toby. Thanks, Miles. Since you mentioned cash management, Toby, I guess there are definitely competing interests here on the lender and the borrower side. You mentioned that from the borrower side, you wouldn't want the cash trap to occur. From the lender side, I suspect I would hear from Aaron and James that they would want actually more control over the cash and use of the cash by the borrower. There is a little tug of war there. I would also throw out there, as far as from experience in the last downturn, where we do have cash management, and maybe it was hard cash management from day one, and there's obviously an order in the waterfall, that the borrower would want to shift some things around in the waterfall. So there might be some reserve requirements toward the top, and further down might be operating expenses, and I suspect the borrower would want to reorder that a bit so that to make sure that the lights are kept on and the property can function, and have somewhat of a curtailment on funding some of the upper items such as reserves. I don't know if anyone has thoughts on that, but I just thought that'd be worth mentioning since you guys brought up cash management. Okay, going back to the lender side on the forbearance, are there, I think on the next slide, are there certain asks that the lender would want to see? And on this slide, we're modifying the loan terms, and there are a bunch of things in here that I think the lender would want to see. So, Aaron or James, one of you want to take us through a number of these items?
Yeah, this is Aaron. I did want to just get back to what Miles said for a second. There certainly is a little bit of attention in terms of how the parties are going to approach the documentation of what's going to happen. As Miles said, an ideal situation for a borrower, guarantor, may be just doing a simple modification. And in today's world, maybe that is the most practical option. But from a lender standpoint, forbearance agreements generally will have a lot of other lender protections and things that are in there that will benefit a lender, particularly if the lender has to move forward with enforcement actions. And examples of these are very clear acknowledgments of a default, a clear acknowledgement that the lender has the right to accelerate the loan, an acknowledgement of exactly how much is owed, and then forbearance agreements typically will have robust releases and indemnities included, and waivers of the lenders and the servicers and the parties on the lender side. And those things can make their way into certain modification agreements, but not necessarily all modification agreements, particularly if you're looking to document a loan modification in a quick fashion. So it's definitely a little bit of a back and forth and a tug of war between the two sides to figure out how to document it and exactly what type of provisions will go in either agreement. Just going back to your question, though, Mitch, in terms of the lender asks, Miles and Toby mentioned things that the relief that a borrower may look for to kind of keep things moving along and keep the project in pretty good standing. There's a whole arsenal of things that the lender could ask for in the forbearance context. I think a lot of them in a one-off situation may be on the table. In today's environment, may be a little bit more difficult. We talked about cash management. Certainly, if a loan has been out there a long time and now we're facing a situation where we have to modify it, whether in the context of a modification agreement or a forbearance agreement, a lender may want to conduct some additional diligence under normal circumstances. Let's go out to the property and make sure the environmental situation hasn't changed in the 8 years that this loan's been out there, or get an updated property condition report. That obviously, for many reasons, may not be practical, may not even be possible in today's environment. So those are things that are out there, but that lenders may not be able to get. Enhanced collateral, letters of credit, additional guarantors, enhanced reporting requirements, really getting more frequent reporting, more detailed reporting. Those are things that would be on a lender wish list under normal forbearance circumstances. Again, may not be possible, may not be practical in today's environment, but those are the type of things that a lender will look to consider in drafting a forbearance agreement.
And from the borrower's side, I think, Aaron, you're correct, and Mitch, you alluded to this, that I think we're probably looking at a document in today's world that would be a blending between the forbearance and the modification, even in the situation where there is no current default. And reasonable enhanced reporting, certain waivers that you may want re-upped or re-acknowledged that are probably already in the loan agreement. From a reasonable borrower side, I would agree to that if we're moving towards sort of the economic relief that's going to be necessary to get everybody through to the other side.
Great. Well, thanks from that perspective. I would think, again, there's also a little bit of a tension between the two parties as far as the ability to do certain things moving forward. From the lender's side, usually, if we weren't in this particular crisis, there would be a lot more stringent controls put on the borrowers to what they can do with respect to the property. On the other hand, given the fluid nature here, I would think the borrower might try to gain a little bit more flexibility in certain things, whether that pertains to leasing activities or maybe even bringing in some deep-pocketed equity owners, not necessarily 100%, but bringing in another equity partner which might otherwise require the consent of the lender. Maybe the borrower would look for a little more flexibility from the lender should that come to light and they have the ability to bring in someone with additional funds to potentially turn this property around.
Mitch, you mentioned one of the elephants in the room. So most of this is coming from the fact, and I think in the outset you said this, we've got tenants that are having problems in this environment. Their businesses are closed for one reason or another. They don't know when they're going to open. And so going back, there should be, I think, a frank discussion with the lender as to, what kind of tenant relief makes sense. Almost put together an agreed upon package of what you can offer to different tenants in different situations to kind of streamline what's going on. Because quite frankly, that for a borrower or a property owner, that discussion is going on both sides right now. So it kind of needs to all coalesce and come together.
Yeah, I would agree with that. I think just one thing to add to that as far as the tenant relief and the tenant modification, I would think that if a borrower is going to have that discussion with their lender, which we know those discussions are already ongoing, that it would have to be a comprehensive discussion, at least from the lender's viewpoint, because just coming and saying, I want to provide relief to these two tenants, well, that's fine because there'll be cash flowing from others, or we think there will, but I think it'd have to look at in its entirety in a very comprehensive basis. Again, recognizing we don't really know where things will go, but I suspect the lender would want to see a little bit comprehensive analysis as far as that's concerned.
And
so,
particularly if it's I'm sorry, Mitch, and particularly, just a quick note, particularly if it's a CMBS transaction where we're talking about a major lease and a borrower is dealing with a CMBS loan servicer who's got to take the proposal with respect to a major lease and then run it by a special servicer. So just another layer of things to think about.
Absolutely. We're heading toward the end of our allotted time. The last couple of things on the slide were considerations for construction loans, hotels, other top property types. For the most part, we've been primarily talking about scenarios where we have multi-tenanted properties. Toby, do you want to hit construction loans and or hotels and say a few brief words as to some of the unique issues that would arise in discussions regarding those property types?
Yeah, I'm happy to. In construction loans, this is somewhat dependent on the status of construction in the particular jurisdiction, and as we've been seeing, some jurisdictions have reclassified what is considered essential versus non-essential construction and have essentially halted what we would say is ordinary construction of commercial properties. For both those projects and for other projects where there might not be government action which has caused overall stoppages, we're in a situation where materials may be delayed in getting to a site, or where inspections are taking longer than we would normally have them take. And we've been encouraging our borrower clients to get in touch with their lenders and let them know what's going on and how their particular project has been affected. And it's not just a matter of, is the construction going to be completed on time per whatever deadline is set forth under the construction documents and the loan documents, but in certain cases we're seeing covenants can be tripped by virtue of tenant improvements that aren't completed on time, and then additional deposits may be required and things like that. So we've been encouraging our borrower clients to take a very broad view of what's coming up in a very lengthy timeline, and get in touch with their lenders now, so the lenders at least put on notice of what is happening and what the ripple effect of that could be. On the hotel side, we know that there are a number of hotels out there who have been donating rooms to healthcare workers and to first responders. And for those owners and operators, again, we're encouraging early communication with lenders. We think this sector is going to take possibly longer than others to recover, and early communication is advisable, especially where the hotels are acting in a way to sort of help the community. We think that to the extent that lenders receive this message, they're more likely to be forgivable down the line, to the extent that it takes longer to recover.
Great, Toby. Thanks for those words. So we're close to the end of our allotted time. What I'd like to do is just turn to the panelists again and ask anyone if they'd like to have any brief concluding remarks. So anyone can jump in. I could start on the lender side. If Aaron or James, you want to throw in a concluding remark, any particularly important takeaway that you want our audience to hear?
This is James. Sure. I would just add, given this time period, you have agency guidance providing for mandatory forbearance period of 90 days at this point in time. You don't have that with respect to CMBS loans and other loan markets. But as a practical matter, lenders are faced with an issue that most state courts are currently shut down, and civil proceedings in federal courts are also slowed down. So as a practical matter, taking enforcement actions right now is difficult, if not impossible. So it's something that the lenders are going to have to consider in being realistic and coming to the table with borrowers for the time being, because they may not be able to take any enforcement actions to the extent that they're in a judicial foreclosure state, for the next quarter or 2 quarters before things start to loosen up and start moving again. So I think that is going to factor into these negotiations going forward.
And just to supplement that, kind of as a last comment for me, as James is mentioning, there's a lot of local considerations. There are also local law considerations with respect to a lot of what we touched upon today. Particularly, what comes to mind is on construction loans. From a lender standpoint, they may be willing to provide an accommodation to a borrower or guarantor, but there may be local laws that have to be complied with in order for the lender to maintain its its mortgage priority. So these are other factors, just another couple layers to keep in mind when the parties are dealing with each other, not only the local on the ground situations, but the local law considerations.
Toby, Miles, on the borrower side, any final points you want to emphasize?
Yeah, just sort of jumping off of what Aaron was saying from the borrower side is that, let's take a construction loan. So, there may be a need at some point to get an advance, but we need to deal with the fact that perhaps a title bring down can't be done because there are office closures, or there may be special circumstances on needing to bond or do something with respect to a mechanic's lien. So there may be certain factual situations, particularly in a construction loan, that the parties are going to need to be creative about and perhaps call in their title company to see what they can facilitate.
Yeah, and sort of piggybacking off of that, I think the overall theme here is really just open communication and some flexibility, that there really isn't going to be one solution to every single problem, and that everybody is going to need to think through, both on the borrower side and the lender side, how do we best solve the current problem that we have in front of us, given what we know about the property, what we know about the borrower, and how do we either keep that property generating cash flow, or how do we just hang on until we can continue construction or take the next step that's going to right the ship.
Thanks, Toby. So we've covered quite a number of important topics today for both lenders and borrowers to be mindful of in connection with dealing with the current environment we all find ourselves in right now. We hope this was helpful to all of our listeners. I want to thank all of the panelists and everyone listening in, and hope everyone stays well and safe. So thanks everyone for your time.
This concludes today's webinar. Thank you for attending.